Good afternoon. This is Anthony Ania from Ania, Scanlon, and Sirignano. I hope everybody is doing well and enjoying this beautiful day. Fortunately, things are getting better with the pandemic, and it looks like, we're going to be moving into different areas of phases of the ability to reopen. We're open at Ania, Scanlon, and Sirignano. Our office in White Plains is open so that we are staffed and we have all the protocols in place and we're ready to help you if you need our help. So I'm very glad that you can join us today. And our topic of this discussion today is how to avoid a will contest. And it's a question that I always have asked my clients, especially if the client has had children that are alienated from them, they have family members that they don't speak to, or it's a parent that is concerned about the children fighting over the estate and the distribution of assets. So avoiding a will contest is something that is often discussed. In fact, I had a lengthy conversation with a client today about it, who has a son who he has not contacted with, has spoken to for the last 10 years, has not seen that child for 10 years, and now he's, doing his will, and he wants to make sure that that child is not mentioned in the will. So what precautions can you take? Well, one of the first things you can do to avoid a will contest is not have a will. And when I say not have a will, does that mean you should never have a will? Of course not. But if you, for example, have a revocable living trust and you've transferred all of your non-IRA assets to that revocable trust, your house, your bank accounts, your brokerage accounts, when you pass away, the assets in that trust are not probate assets. They're not controlled by your will. They're controlled by the trust. And under law, the trust does not have to go through the probate process. So under law, when a beneficiary is cut out and you have a will, that beneficiary, that distributee, has to be provided notice or citation, has to be told that a will has been offered for probate and that they're not mentioned in the will. They're not provided for. They're given a copy of the will, which opens the door for somebody to come to the court and say, no, I'm going to challenge this will. I don't understand why my dad or my mom didn't provide for me. We had a great relationship. And that creates a lot of problems, especially if the parents had a multitude of reasons not to provide for the child. It could be A, that they're alienated from the child, they haven't seen or spoken to the child in a very long period of time, or it could be because the child has drug problems, financial problems. So there are a variety of different reasons why the parents do not provide for the children. Many, many reasons for doing so. So again, when you have that kind of situation, the question is, what steps can you take to avoid your will going to probate and avoid the possibility that somebody can raise objections to the will being admitted to probate? And remember, a last will and testament only controls assets that are in your name alone. For example, if you have a joint bank account, if you have an in-trust for account, or you have life insurance or retirement monies that have named beneficiaries, those accounts are not controlled by your last will and testament. Only assets that are in your name alone. So if you die and you have assets that say John Smith or Jane Smith and they're in your name alone, those assets will be controlled by your will, and the will is not valid until it's gone through the probate process. The probate process is expensive. You have to hire a lawyer in most cases to do it, unless it's a very, very small estate and you can do a small estate administration. But generally, when a will is offered for probate, an attorney's been retained by the named executor of the will, right? Or whoever the individuals are. It could be the named executrix, an old phrase for a female executor. But the individual that's appointed the executor of the will or co-executors are the individuals who petition the court for the probate of the will. And that requires the notice to be given to all the individuals that are considered distributees, individuals that would inherit if there is no will. Remember, when you have a will, you dictate who's going to manage your estate, and you dictate who the beneficiary is going to be. However, if you die without a will, then the procedure is called an administration procedure, and in the administration procedure, anybody can apply to be the administrator of your estate, and then the laws dictate who gets what percentage of the estate. So if you're survived by a spouse and children and you have no will, your spouse will get the first $50,000 plus 50%, and then the children will share the other 50%. Again, that raises issues if you die without a will, because then you have no control as to who specifically is going to get your estate. The law dictates who gets it, and also the law dictates who's going to be the administrator, who applies to be the administrator, rather than the preference being given to the person that you nominated to be the executor of your will. Okay? So when you're going to talk to an attorney about preparing your estate plan, I think it's very important to explore with the attorney right at the get-go as to whether it makes sense for me to have a last will and testament, or would it make more sense to have a revocable living trust. With a revocable living trust, you dictate who the trustees are. In fact, you can be the trustee. You can be the creator of the revocable living trust. You can be the sole trustee. You can then name alternates trustees in case you become incapacitated or you pass away. The assets that are transferred or titled in the name of the revocable living trust are the assets that are controlled by the trust. So if you transfer your house and all of your non-IRA savings, and you have IRAs that have named beneficiaries, when you die, there will be no probate, because you don't have, you don't have any assets that are in your name alone. All the assets are in the name of the revocable living trust, which is a very big advantage. Probate, as I said, you have to generally hire a lawyer. There are filing fees. The probate process, no matter what county you live in, is generally a process that is anywhere from 9 months to 1 year in length. It could be even longer if somebody objects to the probate of the will and wants to have a deposition of the attorney draftsperson of the will, wants to take the testimony of the witnesses to the will. So again, there are opportunities for delay and opportunities for people to contest a will. Additionally, when you have a will, if, for example, you have a family member, a potential beneficiary that is an incapacitated person, a person suffering from a disability, when that probate petition is filed, that individual that is under the disability is entitled to have a guardian ad litem appointed for them. So the court's going to appoint somebody to represent the interest and protect the interest of the person under the disability. Well, that's going to require the guardian ad litem to do a report. That is also going to delay the probate process. So there's the cost of hiring the lawyer. There's the filing fees when you have a will and the probate. There is the delay of potential 9 months to a year before the assets can be distributed. And also the probate process is a public process. Your estate assets are specified in the probate petition. Your will is on record. Technically, anybody can go to the court and look at your file, see what assets you had in your name alone when you died, see who the beneficiaries of your will are. There really is no privacy in the probate process, whereas if you have a revocable living trust, there's no public filing. There's nothing in the public domain that somebody can go look at. The revocable living trust is an agreement between you, the creator of the trust, and you as the trustee while you're alive, or you and your spouse as co-trustees, and then the children as the alternate trustees. The key element to the revocable living trust is the retitling of the assets in the name of the trust. That really is the key aspect. So if you have a house, your house would be deeded to the revocable living trust. If you have bank accounts, they would be retitled in the name of the revocable living trust. So that retitling process in the name of the trust makes the trust the owner of the assets, and then when you pass away, those assets are controlled by the trust and they're not subject to probate. The document is a private document. In that document, you can do all the estate tax planning that you would do in a last will and testament. So when you're when you're doing your revocable living trust, if you want to do estate tax planning and you want to build into the revocable trust a credit shelter trust or a disclaimer trust, or if you want provisions in the document that your children or your grandchildren are not going to receive the assets outright upon your death, that the money is going to be held in trust for their benefit, either during their entire lives or until they reach a certain age, all that can be provided for in a revocable living trust, as it can be provided for in the last will and testament. But the major big difference is, with the last will and testament, in order for that will to be validly recognized by the court and under law, the will has to be admitted to probate. With a revocable living trust, there is no such, proceeding. There is no probate proceeding. There's the element of the privacy. There's no notice given to anybody that the revocable living trust is being terminated and the assets being distributed. Now, it doesn't mean that the revocable living trust is immune from attack. It doesn't mean that at all. Obviously, any document can be challenged and contested. However, challenging a revocable living trust is much more difficult than contesting a will. Contesting a will is a much easier process, and many times it's done by heirs to basically hold up the administration of the estate, even though they may not have any valid claims to contest a will. There is no showing that the individual who signed the will lacked testamentary capacity or was the victim of undue influence or fraud or duress, which are all the conditions to contest a will. Even though there may be no evidence of that, because the will has to go through the probate process, it creates an inroad for this individual to basically challenge the will and hold up the process of administering the estate, marshaling all the assets, paying the bills, and making the distributions to the beneficiaries. However, when you have a revocable living trust and there is no challenge to the trust document, the trustees that are named, or trustee, whatever the case may be, when you die, pays your bills, and then is ready to make the distribution of the assets to the beneficiaries. If there's no estate taxes to be paid, there's no income taxes to be paid, then on your death, the estate could be ready for distribution within a matter of several months. A couple of months should be ready to be distributed. Whereas with the probate process, there are certain filing dates. One filing date occurs within 6 months after the will has been admitted to probate. Then there are certain filings that need to be made. All of these things have deadlines to be done, and there's also time frames within which they can be done. Again, the whole process of probating a will from beginning to end, 9 months to 1 year. Okay? So it's important to speak to your attorney about whether a will is the proper document for you. And if in fact you are omitting from your plan certain individuals, such as children or grandchildren, then you really want to tell the attorney and be specific with the attorney that you are omitting these individuals, and give great detail to the attorney. If the attorney that you're consulting with is not writing all the specific reasons why you're not providing for a child of yours, that will is going to be easier to contest. The attorney that you're seeing should go into great detail as to why you've decided not to provide for the individual that is your child or grandchild, whatever the case may be. So, and what we do in our documents, we put a specific provision in the documents that say, I am intentionally not providing for my son Jim, whatever the case may be, and any of his children, issue. So we make that specific language in the documents that we prepare. Also, we put in a very onerous no contest clause. Basically, the wills and trusts that we do have provisions in them that if anything any beneficiary does or any individual does that would seem to be a contest or a challenge to the will or trust, unless that individual wins, they're not going to be entitled to any money. So that sometimes is a problem when, for example, you're not making equal distributions of assets. You have 3 kids, but one child is getting 50%, the other 2 children are getting 25% each, and the two that are getting the 25 feel like they're being shortchanged. So what you would want to do is you would want to, explain to the attorney the background, the family history. Why are you taking care of this individual to a greater extent? Why are you providing more for them? For example, is it because that child lives with you, or that child takes you to the doctor's appointments, mows your lawn, takes care of your house, takes you food shopping? All of these kinds of things should be articulated to the attorney so that the attorney has a good sense and understanding of why you're making these specific provisions. Okay? So use a revocable trust, a much better vehicle. Work with an experienced attorney. If you have a significantly sizable estate, several millions of dollars, and you're going to be cutting out an individual from your will or trust, you really want to work with an attorney that's an experienced estate planner, someone that has gone through this process and knows of the potential risks of a will contest. Provide your lawyer with as much information about your estate. Provide them with a detailed list of your assets. Provide them with a list of the names and addresses of the individuals that you want to inherit. Provide them with the names and addresses of your entire family if necessary, especially if you are not providing for your family. What you want to do is you want to give that lawyer that you're hiring the ammunition to fight back against a will contest, to be able to say to the court, to the person taking their testimony, I obtained all of this information from the client. The client was very detailed. He told me exactly what bank accounts he had and how those bank accounts were titled and how much money was in the bank accounts. Not only did he or she do that, he provided me with the list of all these accounts. He provided me a list with the members of his family, a family tree. Meet with the attorney that is doing your will alone. If there are, for example, children that you're not going to provide for, and you're only providing for one child, well, don't have that child there at the consultation with your attorney. It's always better for the lawyer to be able to say, I met with my client alone. My client told me XYZ. He or she told me that they did not want to provide for their son or daughter for the following reasons. And that ability for the lawyer to look at their notes and articulate what you told them about your wishes is invaluable. It really helps defeat the will contest. Also, when you're meeting with your attorney, do not be reluctant to tell your attorney about your health and medical condition. It is always important that the lawyer know what your condition is. Because if the lawyer does not know what your medical condition is, perhaps at a deposition he or she now will be surprised. So I always go through the process of asking the client in great detail about their medical condition. Do they have any major illnesses? Do they have any neurological conditions that they've been diagnosed? For example, have they been diagnosed with dementia, Alzheimer's, Parkinson's? And how long ago were they diagnosed? Are they taking any medications that would impact their cognitive abilities, their ability to reason and make decisions? For example, are they taking psychotropic medications? Individuals that have bipolar conditions or schizophrenia may be taking psychotropic medications. You really need to know that if you're going to be preparing a will that's going to be able to withstand any challenges for that individual. So obtaining as much information as possible by the lawyer doing so is very important. But you as the client are a very important element. I've had clients come in, and even though we've asked them to provide a list of assets and names and addresses of their family, they just walk in cold. They don't bring any of the information. And it's not really helpful to the lawyer because the lawyer cannot do due diligence. They're unable to really do a very good job in representing that client who is unprepared. So there's a job that the lawyer has to do, and there's the job the client has to do. And the job and the responsibility of the client is really to give the lawyer as much information as possible so that they can adequately represent them, do their due diligence, and then have a file, have a paper trail that allows that lawyer to basically, fight off any will challenge, because that lawyer is going to be the first defense. If there's going to be cracks in that lawyer's wall where the lawyer doesn't know things, where the lawyer didn't do a thorough review of the individual's assets, didn't get details as to why the individual was not providing for a family member, if there's going to be a will contest, it's that lawyer presents the first avenue of defense, and if they're not able to adequately defend the will, there's going to be problems. It's going to weaken the ability of the estate to fight off the challenge and may have to unnecessarily settle with somebody that doesn't even have a meritorious claim. So what you want to do is provide the lawyer with as much detail as possible. Tell the lawyer about your medical condition. Tell the lawyer about your assets. Be prepared when you go to see the lawyer. The other thing that you should try to do is not avoid seeing the lawyer more than once. Sometimes clients say to me, well, do I have to come in to see you? Especially with the COVID-19 pandemic, a lot of clients have asked me, well, can we avoid seeing you at all in person? Well, we can have that initial consultation on Zoom or Skype. We can do that. But when it comes time to signing the document, it's important to meet with the client personally, to be able to assess the capacity of the client to sign the documents, making sure that the client understands what they're doing, that they have knowledge of their assets, etc. So the will signing is an important event. And also what I like to do is I like to, if all possible, have an in-person review of the documents with the client. So by the time we're done with the plan, there's been 3 areas of contact with the client: the initial consultation, the consultation to review the documents, and the third consultation, which is to have the documents signed. Okay, so that contact between lawyer and client is important because the lawyer should be documenting the conversations, etc. Okay, so very important for you to look at all these issues before you go out and hire a lawyer to do your will. You're looking for somebody with experience. You're looking for somebody who understands what happens in the will contest. Fortunately, I was involved in many will contests for many years. I took many depositions in will contests. I took the testimony of attorneys. I took the testimony of the witnesses, of the individuals filing the objections to probate and defending the objections to probate. So I'm very familiar with what happens at a will deposition and a will contest deposition. And that familiarity allows me to best achieve the client's goals and be able to protect the client's assets. Okay, so very important that you take these steps. And it was nice talking to you folks again. And if you have any questions, always feel free to email me your questions. And we're always here available to help you with any of your elder law and estate planning needs. As many of you know, we do both wills, trust, and estates planning. We do asset protection planning, protecting assets for Medicaid eligibility. We do guardianship proceedings. We do special needs trust. We do Medicaid applications, home care and nursing home applications. And by the way, there is a major change coming to home care Medicaid eligibility in October. And if you really haven't taken any steps to protect your assets, it really is the time to do that now. So thank you very much. And again, it was nice speaking to you. And stay safe and stay well. Talk to you soon. Bye-bye.